changes to landlord-tenant law. That notification and the information that just popped, notification that just popped up on your screen is to remind you that we will be recording this meeting. The City of Davis, who I'm doing this presentation in conjunction with, will be recording today's session, and it will be made available to folks later on down the road, which means a couple of things. First of all, when we do get to the Q&A, I want to make sure, just because this is going to be recorded and publicly available, that we protect everyone's privacy and confidentiality. If you do have a question, try to keep it as general as possible without using property addresses, people's names, things like that, just to make sure we protect everyone involved, including yourselves, of course. Also, just note in asking your questions, the nature of the questions, also that this is going to be recorded and publicly available down the road. If you have some specific questions that you either don't feel comfortable sharing here in this semi-public forum, or go into a little too much detail for a presentation or for questioning in this session, then at the end of the presentation, I have my contact information for you, email and phone number. You're absolutely welcome to contact me directly after the session. I'm happy to follow up on any questions here that we don't fully answer, or if you still have further questions after hearing my answer, or if you have a question that you prefer to ask offline, we can certainly do it that way. So I'm stretching out the introduction as well, so that we give a few more folks time to join. I know we had a lot of people pre-registered for the event today. This is the first of a series of 4 presentations, which I will be giving. The full schedule is on the flyer, which you've probably seen since you registered for this event today. But just go ahead and mark your calendars now for the next presentation, which is on Tuesday, September 16th. That will be discussing the move-in, move-out process and security deposits. Always lots of questions around both of those areas. And with the presentation being just after, when many leases turn over in Davis at the beginning of September, I'm sure you all will have lots of fresh examples and questions for me to present at that session. So I'm looking forward to that one as well. In terms of, let me tell you a bit about myself, and then I'll tell you how we're going to run through the program today. I am, as I said, an attorney. I've been practicing since 1996, which will, believe it or not, somehow be 30 years next year. I came to Davis in 1989 as an undergraduate. And so I have lived in the dorms, I've lived in apartments, and I've lived in homes, all in Davis since 1989. Uh, I am a member of the Cal Aggie Alumni Association, Aggie Athletics booster, have twice been president of the Yolo County Bar Association. I'm currently the secretary for the County Bar Association as well. And I'm also this year the board chair for the Davis Chamber of Commerce as well. So definitely well versed in the ins and outs of Davis over the years. And I've been involved with various community organizations as well as my private practice, which does landlord tenant law and other aspects of civil litigation as well. So that's a little bit about me. A little bit more about today. We're going to go over, as I said, the topic today is changes and updates to California landlord tenant law. This presentation is geared primarily towards the landlord side, although obviously tenants need to know all of this information as well. And I have represented and do represent both landlords and tenants, but primarily do my work on the landlord side, just advising them primarily with what's the right notice to give, when to give it, what's supposed to be in it, those sorts of things. And then if there are disputes, trying to get those disputes resolved either outside of court or in court through an eviction proceeding or other sorts of civil actions dealing around security deposits and that sort of thing. In terms of the logistics today, as you see here from this outline, we do have a lot of information to cover today. So I'm going to try to spend the first 45 minutes or so getting through all of this information. So I'd ask all of you participants to please remain muted until we get to the question and answer session towards the end of the presentation today. Then we will probably just have you raise your virtual hands so we can get to as many questions as we can in the amount of time that we have left. As I said, if we run out of time for your question or you don't feel comfortable asking that question in this forum, that's totally fine. You can contact me after the presentation, either by email or by phone. And I'd be happy to explore your questions then. So I want to just briefly mention the subject matter that we're going to hit here today. Now, the slides that I am presenting today and all the information that's on them will be available also through the city. They will be making not only the recording of today's presentation available, but also copies of these slides. So if you missed something during the presentation today, don't worry about that. You can either reach out to me or to the city directly, and we can get you a copy of these slides and that information. So today we're going to be talking about new restrictions on when you can and can't charge an application screening fee, the amount of those fees, how you charge it, when you charge it, who you can charge. Changes to the total amount of security deposit that you are allowed to collect and retain as a landlord. Your duty, a new duty to notify tenants that they have a right to request positive credit reporting, which means if they make this request, then you as the landlord are obligated to provide reports to at least one credit reporting agency that they have been paying their rent on time. So that helps them build better credit. And we'll go into the ins and outs of what that requires and how it's done. I mentioned screening fees, but there's also sort of some more general considerations to keep in mind in terms of fair housing requirements. Those can be different in and out of publicly subsidized housing, and things to keep in mind when you are screening applicants and accepting applications to fill spaces. The new requirement that you are required to take and provide to the tenants photographs of the property's condition at various times before and after the lease, what you're required to do and how you're required to do it. A new requirement relating to domestic violence situations. If there is a domestic violence situation and the tenant requests that the locks in their unit be changed. What are your obligations? How do you do it? When do you have to do it? Those sorts of things. For those of you in multi-unit complexes or other places with elevated balconies or other exterior exposed areas, there is a state law requirement that you are required to have those inspected. Arose out of some tragic stuff that happened in Berkeley and elsewhere in the last few years. There's been some adjustments to that deadline that allows you actually more time to comply, which we'll talk about. The requirement, again, for multi-unit complexes of energy efficiency benchmarking, that you have to report your energy usage for the units to the state of California. Who has to do that and when and how, we'll talk about. And then lastly, there have been some changes in the last few years to the timelines for eviction lawsuits. Unlawful detainer is the name for an eviction lawsuit. And because it's a very specialized type of civil litigation, the timeframes for bringing those actions and to respond to them and to get them to trial are very much shortened so that you can get resolution of the issue of possession of the property resolved quicker than you might otherwise. But there have been some extensions of time that we will talk about in a moment. And as I said, when we finish getting through all of that material, hopefully we'll still have some time left at the end for questions and answers. And feel free to ask questions on any of these topics if I was not clear about something, or if you want to ask a question about another topic that's not on the agenda for today, I'm certainly open to that as well. Let me go back for a second just to sort of set one more thing to set the tone. One of the most important things that apply to most of these are that the new requirements may or may not apply to you, depending on the type of landlord that you are. I certainly have worked with folks that have one rental property all the way up to property managers or owners of large multi-unit complexes. So there may be wrinkles and changes depending on how these rules may or may not apply to you based on what type of landlord or property manager you may be. I'll try to hit those as we go through them to the extent that I can, but there may be a question as to whether or not any of those may apply to you. Again, the information that I'm providing today is sort of general information about what the law says. The application of those laws to your situation may vary. So none of this is legal advice. This is just information for you. This does not create an attorney-client relationship with any of you who may be watching today or in the future watching the recording of this. As I said, if you do have specific questions about your situation, certainly feel free to contact me or any other local attorney who may be able to help you and provide specific advice about your situation. So now with the stage set, let's get into the nuts and bolts of today's information. I want to start with application fees because there has been a change effective this year that basically limits, and then we'll have a few slides on this, that limits when and how you can charge a application screening fee in the first place. In general, if you want to charge everyone an application fee and retain that fee, then you have to meet all three of these requirements. You have to have written screening criteria that are given to the applicants at the time they request the application. If for larger complexes, for everyone, it's a good idea to have written screening criteria, even if they're very simple. We need, if you do a credit check, that one of your criteria is that you perform a credit check and you review the results. Then you have to think through what sorts of things on a credit report that I get back would be a problem for me. What would I use to screen? Am I going to use a certain amount of income? Am I going to use a certain credit score? And if so, that should be clear, and you should have that in writing and consistently apply it to all your applicants. If you're not going to do that, but you have other screening criteria, you need to the best extent that you can, articulate what those criteria are. The second requirement here is that the landlord accepts applications and reviews those applications in the order that they are received. So, sort of first in, first reviewed type thing. And then the final requirement is that you accept the first applicant that meets your screening criteria. So if you get 10 applications and you go through them all and the first applicant meets your screening criteria, that applicant should be offered the unit. You can then go on down the list if they don't accept, for example. But if the first one doesn't and the second one doesn't and the third one does, then you're supposed to accept the third. If you follow all three of those rules, then you can charge an application screening fee to all 10, and you can retain that fee for all 10. You just have to offer the unit to the first applicant that meets the screening criteria. And then if they do not accept, you can move on down the list to the next one. In terms of the amount of the fee that you are allowed to charge, they're capped at the actual out-of-pocket cost to conduct the screening. So if, for example, you do obtain a credit report, you can use the fee that you are charged to receive the credit report as part of your actual costs of conducting the screening. You're also allowed to include the reasonable value of time spent by yourself or your agent in obtaining and reviewing the information. There's not a lot of rules about how you value that reasonable time, how much time they spent, what dollar amount you place on that is not specified by the law, but it has to be reasonable. So if you add those two elements together, that can be your application fee. The statute caps the application fee at no more than $30. So actual costs or $30, whichever is less. But it also states that you can adjust that $30 cap upwards based on the CPI increase since the date of that law was enacted, which was 1998. Would have been nice if they had just updated it, since 1998 to a more reasonable contemporary number. But I did go to a CPI calculator and put in $30 in 1998, and that now would be $59.88. So the cap is somewhere around $60 or less, depending on what your actual out-of-pocket costs are, plus that reasonable amount for your time in reviewing the application. Another important new restriction is that if you know at the time someone applies that there is no unit available, or there will not be any unit available within a reasonable time, then you may not charge an application screening fee. You can still accept their application and hang on to it until there is a vacancy, but you cannot charge them a fee at that time. When a unit becomes available, you could then charge the screening fee and conduct the screening, as long as you follow the rules that we just talked about on the last slide. In terms of, so this is sort of an outline of the new requirements. The first qualified applicant approach here, which is the item number 1, is basically the process that I talked about on the earlier slide. You give the applicants written criteria, approve the first applicant who meets the established criteria, and then applicants are not charged a fee unless or until their application is actually considered. So in that case of the 10, if you never actually consider number 8, 9, and 10 because you gave it to number 7, then you should refund the application screening fees of numbers 8, 9, and 10 because you never actually considered those applications. If you select from among all applicants, but you don't use written criteria, you don't provide written criteria to the applicants, that sometimes can be a situation either if you don't have written criteria to give them, or if you're a very small landlord, you only have one unit, you've decided not to establish written criteria to review. You just want to look at all the applications and then pick the one you want to award it to, whether or not they're the first one that applied. You can still do that. However, you have to refund the screening fee of all applicants that you do not select, regardless of reason. So if you get 10 applications and you don't use this first qualified applicant approach, you can still do that, but you have to refund the application fees of the other 9 applicants that you do not select. And you're supposed to do that within 30 days or within 30 days from receiving the application or within 7 days of actually selecting a tenant, whichever is earlier. I mentioned earlier that, best practice, of course, and it helps you avoid potential issues or fair housing claims or discrimination claims down the road. The best practice is to have clear, preferably written, screening policies that you apply uniformly to all applicants. Now, landlord-tenant law is a strange animal in that there are lots of interesting wrinkles and different fact situations and reasons why you might want to make exceptions from time to time. That's all true. But in general, you want to have written screening policies that you apply consistently to everyone. As I mentioned earlier, if you want to follow the first qualified applicant approach, then one of the requirements of that approach is providing the applicants with a copy of your screening policies. If part of your screening policy is using things like credit checks or asking for referrals from previous landlords, etc., as part of your screening process, then consistently use them and apply uniform standards to the results. Now, it's sometimes difficult to do that because the specifics of the credit report you get back are different from applicant to applicant. The wording that landlords use in their referrals can be different from landlord to landlord. So to the extent that you can, you want to be as even-handed as you can in applying your screening rules. If you are applying your screening rules and you get a credit check response back, you review a credit report for a tenant, and based on your criteria, you are denying them due to that credit information. You are required now to provide a copy of the report to the tenant within 7 days that after you receive the report, regardless of whether or not the tenant requests a copy. The previous rule was that the tenant had to ask, they had a right to get it from the credit reporting company, um, and they had a right to ask for it. Now, the requirement, since you will have a copy of the report, is that you are obligated to give them a copy if you use it as part of your decision, whether or not they ask for it. And they get it directly from you, not from the credit reporting agency. The tenant still does have the right to go back to the credit agency and dispute any late payments or charges or whatever that they contend are inaccurate. And generally, it's a good idea as the landlord to allow a little bit of time for that process to work through. If the credit reporting agency actually changes the report and that changes your decision, you need to allow time for that process to happen. If they dispute a charge that you've used as the basis for denial, and then you move on to the next tenant and move them in, then the previous applicant gets the negative information removed from their credit report. Potentially, they could have a claim against you for denying them that lease and offering it to somebody else. So be aware of that and allow potentially some extra time for those sorts of things to work through. The amount of security deposit that can be charged, the total amount of the security deposit has now changed as of July 1st of last year. The previous rule was up to 2 times the monthly rent for any unit, or if it was a furnished unit, you could charge up to 3 times the monthly rent as the security deposit. That law has now changed, effective July 1st, 2024. So if you have not already, please update all of your leases going forward. The security deposits are now limited to 1 month's rent for both furnished and unfurnished units. So not only is it no longer 2 or 3 times, it's 1 time the monthly rent for both furnished and unfinished units. Now, here is one where there is an exception for small landlords who own no more than 2 rental properties with no more than 4 total units can still charge up to 2 months' rent as a security deposit. But anyone with more than 2 properties or more than 4 units is limited to 1 month's rent for furnished or unfurnished units. But a mom and pop, so to speak, a landlord or property manager who manages 1 property on behalf of someone can still charge up to 2 months rent, just as a little disclaimer there to that general rule. There is a new rule as of this year, and there's a slightly different dates that they go into effect. But the new right that tenants now have, and the policy behind this is to help tenants build better credit. Tenants now have the right to request the landlord report their positive rental payment information to at least one nationwide consumer credit reporting agency. So because they now have that right, you now have the obligation as a landlord to notify them of that right. And if they exercise that right, then you're obligated to make those reports on their behalf. For any new leases that were starting on or after April 1st of this year, so that's anything that's happened over the summer or that will happen starting in September, although many of those leases have probably already been signed, Davis being Davis. The tenants are supposed to be notified at the time of the lease agreement and at least annually thereafter. So if you have a lease that's already signed that is going to be starting in September, but you have not notified the tenants of this right, now would be a good time to do so. There are templates out there that you can use to provide the notice. The statutes actually list the language that you're supposed to use in the notice. I didn't put a template agreement in here, but anybody who's interested in getting one, and it's very simple, uh, just notifying them of this right. And it's usually also a good idea to have, a form or a checkbox or something on that notification that they can return to you if they're going to be opting in to that. If you have a lease that was already in effect on January 1st, 2025, so that's leases that are currently ongoing, maybe that started last September and are going through this August, the landlords were supposed to give notice of this right no later than April 1st, 2025. And this is not a one-time notice. You are obligated to notify the tenants of this annually every year. Uh, the most efficient way to do that would be to just include this notice in the lease agreement that they are signing every year. So that's one way to go about it. Another way to do it is to just put a reminder on your calendar every, April or every August before leases start, or every September as leases start, to send a notice to all of your tenants notifying them of this right. So whether or not someone's exercised the right in the past, when they get the new notification each year, they have the opportunity to opt in at that time. There are some exemptions to this requirement. Generally, owners of any building with 15 or fewer units are exempt. So certainly single-family homes, those sorts of things are generally exempt from this. There are exceptions to the exceptions, of course, in this case. If the landlord owns more than one building, regardless of the number of units, then they still are subject to this new requirement. Or if the landlord is a real estate investment trust or a corporation or an LLC in which one of the members of the LLC is a corporation, then this right still applies to their tenants. So the exemption is for owners of a single building that has 15 units or less. Those are exempt as long as the owner is an individual, not an investment trust or a corporation or an LLC. A little bit more about what that rent reporting obligation requires. First of all, you can charge the tenants a fee for this service. The fee must cover your actual costs up to $10 a month. So hopefully your cost will be less than $10 per tenant per report. This requirement is a reporting obligation for positive rent payments only, meaning if the tenant makes a complete and on-time payment, then you are obligated to report that payment to the credit agency. If they make a late payment, if they make a partial payment, or if they don't pay, you should not report that to the credit reporting agency. So it's a sort of a one-way obligation. You only report the good stuff, not the bad stuff. I think in practice how this will work out is if they see a record of on-time payments, but the record shows that they paid on time in January and February and July and October, then the credit reporting agencies can kind of read between the lines and say, well, I didn't get positive report in these other months, so they must not have made complete on-time payments in those months. Tenants have the right not only to have this positive reporting done for them, but they have the right to opt out of this reporting at any time. So, for example, a tenant who stops making timely full payments of rent might opt out of this credit reporting. And if they do so, then you're supposed to stop reporting. If the tenant exercises their right to opt out, they cannot opt back in for at least 6 months. So that is, and that restriction on opting back in is generally part of the information that you give them in the notice, and in the checkbox form where they're opting in or opting out of the rent reporting right. Oh, let me go back one more. As I said, the best practice, especially for medium to large size landlords or management companies, is to have a standardized written notice that you provide to tenants, or just incorporate the language right into the language of your lease agreement, and provide the tenants with a form, and then give them that notice and form again annually to opt in or opt out. The opt-out notice should also be available, in your rental office because, as I said, a tenant can come in and opt out at any time. So if they do that, you want them to do that in writing. Best to have them, take out the form, have them check the box and sign the form that they're opting out. In terms of how you comply with this obligation, as the landlord or management company, you could contact directly the credit reporting agencies. And again, you're only obligated to report to one or more. So I presume most folks will only do one, unless you work with an agency or organization that will do reporting to all agencies for you. Uh, and in that vein, you can contract with an outside compliance company that will take the information that you provide to them and then make the reports to the credit agencies for you. That is certainly easier, but more expensive to do than doing it directly. Also, it's important if you're going to work with an outside company that they understand and respect all of the confidentiality requirements of the personal financial information that you're providing to them, that they are then reporting to the credit reporting agency. There's one more little wrinkle on this before we move on to the next topic, and that is in subsidized or assisted housing developments. The tenants do still have the same right to request rent reporting, but the reporting that is made to the credit agencies is all payment history, not just positive payment history. So in a subsidized or assisted unit, if a tenant has requested this, then you report all payment history to the credit reporting agency. And they still have the same rights to opt out and the same restriction of 6 months to opt back in after that in subsidized or assisted housing developments. Photographs of property condition. This is a new requirement as of July 1st of this year. The requirement for photographs actually started last year, but there's now a new additional wrinkle and a third time when the landlord is required to take photographs of the property. 3 different times. Immediately before or at the start of tenancy. So that would be ideally before move-in or at the time the move-in inspection is done with the tenants. It might be advisable to do that, take those pictures, in fact, while the tenants are present, because then you have additional witnesses and proof of when you actually took those photos. The indication, most digital cameras and phones nowadays do indicate the date and time and location in the metadata when the photos were taken, but sometimes there could be disputes about when the photos were actually taken. If everyone's present at the same time when they're taken, that helps. But at the beginning of tenancy, then again, within a reasonable time after the property is returned to the landlord, but before any repairs or cleaning are done for which the landlord will make a deduction from the security deposit. That's the new requirement. You can understand why that might make sense. At the end of the lease, after the move out, when you are getting ready, you need another inspection of the condition of the property. You want to document the condition of the property at the end of the lease by taking pictures before any repairs or cleaning are done. That helps you show why the repairs or cleaning were necessary. Here's the broken window. Here's the dirty carpet, that sort of thing. A picture of it with a date and time after the tenants vacate and before you do the work will help show why the work was necessary. And then, once you do any repairs or cleaning, you take a third set of photographs after the repairs and cleaning are completed. That helps you prove that the work was actually done and that the repairs and cleaning were necessary and that they made a difference in the condition of the unit. So now 3 times that photographs are to be taken by the landlord. Retain those, obviously. And it's a good idea to retain them for some time after the lease is terminated. There could still be a dispute over the return of the security deposit, the condition of the property. There could be a question about the new tenants who move in about the condition of the property. And if you have photos that showed what it looked like after the repairs and cleaning were done, then you can use those in response to a new tenant who comes in and says, "Yeah, but the window's broken," and you can show them the photo of when showing the window had been repaired. Uh, so copies of those photographs must be provided to the departing tenants, and also retain copies, of course, in case there are disputes. The law is not clear about how you are required to provide those copies to the tenant. The easiest way to do it, obviously, is to email attachments. But if a tenant requests hard copies or something like that, arguably you might be required to print them out and provide them. If the tenant doesn't have an email address, for example, for whatever reason, or is old school and wants paper photos, then it's probably better to provide them than to get into a fight about whether or not you're required to do so. If deductions are made from a tenant's security deposit, the required itemized statement, which you issue within 21 days after the lease is terminated, that required statement must include copies of the photographs showing what was repaired or cleaned, together with any bills, invoices, or receipts to support the deductions. Now, previously, the requirement was that if you incurred outside costs, not just your staff cleaning, but you hired a cleaning service, or you hired painters, or you hired a window company to fix the windows, you're required to include those invoices, receipts, showing those costs to support the deductions that you make from the security deposit. You now also are required to include photographs of the things that were repaired or cleaned with that statement. I skipped ahead. There we go. Okay. Balcony inspection requirements. This actually was a requirement that was put into place a year or two ago, and the compliance deadline was January 1st, 2025. However, that was extended now to January 1st, 2026. So, luckily, for those of you who either have not heard of or have not complied with the balcony inspection requirements, you now have until January 1st, 2026 to come into compliance. This requirement applies to any residential landlord that has 3 or more multifamily dwelling units. They are required to obtain an inspection of all balconies and exterior elevated elements. So that could be a patio cover. That could be a dormer, landing, a balcony, obviously balconies of all kinds. Any other exterior elevated element that could potentially come down should be inspected. Once that initial inspection that is required right now is completed, you have to have them re-inspected at least every 6 years. So there is a little bit of a reprieve. Once the inspection is done, you don't have to do another one for 6 years. You want to maintain copies of your inspection, of course, and there are specific examples here of the individuals that must conduct the inspection. You can't just have any old person do the inspection. It has to either be a licensed architect, a civil or structural engineer, or a building contractor with specific licenses that has at least 5 years experience in constructing multi-story wood frame buildings, or a certified building inspector or building official from a recognized jurisdiction. One thing I would note, however, is the individual who's certified as a building inspector or building official cannot be currently a building official for the city in which you are having the inspection done. So here in Davis, for example, you can hire a licensed building inspector from West Sacramento or from Solano, but you cannot hire a building inspector from the city of Davis to do your balcony inspection here in the city of Davis. So those are the categories, and those are the only 4 categories. Your inspection has to be conducted by one of those 4 types of individuals. And again, retain a copy of your inspection. If they recommend any repairs or maintenance, I certainly recommend that you have those repairs or maintenance completed as soon as possible, and maintain records that those repairs were done as well. Usually, if repairs are necessary, that will require, in Davis being Davis, that will probably require a building permit, or at least the review and approval of the building department. If you have those repairs inspected and approved, then maintain again all of those records so that you can show that you have done that. Domestic violence situation. This is another new law from this year. If a tenant notifies the landlord that the tenant or a member of their household has been a victim of domestic violence and requests that the locks are changed, the landlord is required to change the locks at your own expense within 24 hours of being notified. Now, this doesn't have anything to do with whether or not there is a restraining order or is not a restraining order, or there is or is not a pending criminal proceeding. If they have given you that notification and they request a lock change, you are required to change the locks. And you are not, it is not necessary or really even appropriate for you then to require or demand any further proof or documentation from the individual. The landlord's obligation is to change the locks. I can foresee some situations where that may get you into hot water with the other tenant who either claims it didn't happen or is now locked out or whatever. Or in multi-roommate situations, this can certainly get touchy as well. So certainly probably seek legal advice on how best to handle those sorts of situations. But the law requires you to change the locks once you've been notified and that request is made. If the landlord fails to change the locks upon request, the tenant can take it on themselves to do it, and the landlord is required to reimburse the tenant within 21 days of that change. If the tenant does change the lock themselves, they are required to notify you within 24 hours of making the lock change. They will probably do that anyway because they will try to make you pay for it. But they're also required, if they change the locks themselves, they are required to provide the landlord with a key to the new locks, which makes sense. Okay, wrong direction. There we go. Energy efficiency benchmarking. I think this might be the last one before we get to our Q&A, which is good because we've got about 15 minutes left. This is actually not a new requirement, but there are some new tweaks to it. So I wanted to make sure, first of all, that everyone was aware of it. It applies generally only to large commercial buildings and residential landlords with relatively large, more than 17 units. So larger landlords, but many of the apartment complexes, for example, here in Davis, certainly would fall under this benchmarking requirement, which has been in place since 2018. However, the regulations to implement it were not finalized and published, I don't believe, until 2021 or 2022. So they've been fairly generous, I shall say, in enforcement proceedings and those sorts of things in terms of these benchmarking requirements, but it is a requirement that you should be aware of. Determine whether or not you're subject to it and what you need to do to come into compliance, if so. I did link here to the website at the California Department of Energy that has general information about the program. The reporting is done online through their portal at that website. You can find out whether or not you're subject to it and what you need to do to get into compliance, if so. The most recent change to that requirement is that in 2023, there was a requirement added that in the reports that you're required to submit, you're required to obtain a benchmarking reference number, which you do again through the website above. And that number references basically allows them to track your property a little more straightforward based on that number, reference number, and you include that number in your reports. The basic requirement is that you're required to obtain energy usage information from PG&E or Valley Clean Energy and or whoever else you are obtaining your power from for your units, and report that information to the California Energy Commission. And similarly to the credit reporting requirement, a landlord can directly report this information if they can obtain it from PG&E or whoever, and then input it in through the portal. There are also various companies out there that market themselves as assisting landlords and property owners in complying with these requirements. So you give them your property information, they act as your agent, they go obtain the energy usage information from the utilities and then fill out the online submission on your behalf. There is one more subject matter area that is important when push comes to shove, and it is time, unfortunately, for an eviction proceeding in order to resolve a dispute over possession, whether it's for non-payment of rent or violation of rules or any other lease violations. Uh, the court proceedings for unlawful detainers the timelines are very truncated as compared to other types of litigation. The For non-payment of rent, you issue a 3-day notice to pay rent or quit. If rent is not paid within those 3 days, then you can go to court and seek a court order returning possession to you as the landlord. Um, the uh, Expiration of 3-day notices, and this can be factored into when you decide to serve a 3-day notice, is that if the 3-day notice expires on a weekend or day or holiday, so for example, if you serve it on a Thursday, then the 3 days expires 3 days later on Sunday, then it doesn't actually expire on Sunday. The tenant has until the next business day or the Monday to vacate or pay rent. So if you filed your unlawful detainer action on Monday based on a 3-day notice, that's too soon because the notice hasn't actually technically expired until the end of the day on Monday. Now, the change is once an unlawful detainer lawsuit is filed, the tenant used to have 5 days to respond. And just like with the 3-day notice, if that 5th day fell on a weekend or a holiday, the tenant has until the next business day to respond. The new rule is more generous than that in a couple of ways. It's still a very short timeline, but it's 10 business days, which means the tenant has 10 days that are not weekends or holidays to respond to the unlawful detainer lawsuit. Once they are served, they have 10 business days. So, if they are served on a Monday, they get those 4 weekdays after that, and then the 5 weekdays of the week after that, and then the 1 weekday of the week following that. So the 10 business days from a Monday is really 2 weeks. And if there's a holiday in any of those weeks, then there's even an extra day tacked on. So normally, previously, you would be able to go right to court and file a request for a default after 5 days. Now it's 10 business days. So that is the change to the unlawful detainer timelines. We have reached the end of the presentation for today. That was quite a quick overview of the most recent changes. There are many more, and there are many more details, as I said, about all of those. We're going to open it up now, hopefully, for questions. I am going to ask city staff who's been helping us monitor today to kind of help me spot folks. If you have a question you would like to ask, you feel free to, and hopefully we can, it's either already set up or should be able to unmute yourself. You can request to unmute yourself if it's not working, or raise your hand, your virtual hand. We will be on the lookout for you to ask questions. In addition to that, as I said earlier, you can also email me after this presentation is over, or call me at my office number is right here on this slide. Happy to talk with you individually about the details of your questions. I think the last disclaimer I have on this is I'll remind everyone, because we are recording this and it will be rebroadcast, please don't use specific names or property addresses of anyone who may be involved in your situation as part of your question. But if you do have a general question, either about anything I covered today or other landlord-tenant topics that are on your mind, now's the time to bring it.
Hello?
There we go.
Hi, Gordon, go ahead.
Yes, thank you very much, by the way. This is great. I really enjoy what you're doing. I appreciate it. Mr. Carlock, my question is this. I have a small rental property, and the plan is that when I retire, I'll move into it. And so my wife actually follows that next door, and I've heard of stories where people, even family members, they've tried to evict them. It took 6 months. And let's say I sell my big let's say I sell my big house and, I want my tenants to move out and I give them the proper notice. How long can they potentially drag their feet? Because, there could be time, the timing is, is sometimes kind of tight.
Yes, that is a good question, and obviously, you don't want to have it sitting vacant without your current residents, uh,
I mean, I could
on
put
the
the,
market but not being sold. But
yeah, exactly.
and the lawyer answer, of course, is it depends. You do want to build in enough time so that you could, generally, you're probably going to want to be giving your tenants at least 30 or 60 days notice to vacate.
Mhm.
If you are taking the property off the rental market because you are planning to move in, that is a criteria where you can give 30 days notice if they've been there less than a year, or 60 days notice if they've been there more than a year.
Mhm.
And but if that 60 days expires and they don't vacate and you need to evict them, then optimistically you probably would need to factor in at least several months of time for that to work its way through the court process, because you have to file the lawsuit, you have to serve the tenants with the lawsuit, and if tenants are holding over, they probably aren't too interested in answering the door for a process server either. So that can delay the process. If they file a response with the court, then you have to set it for a trial. They usually are held within about 3 weeks of that time. But again, there's a couple more weeks. Then, if you have the trial and prevail, then you have a judgment in your favor. If the tenants still do not voluntarily vacate, you have to have the sheriff serve that judgment on them. And then the sheriff will come back eventually, if necessary, and lock them out and return possession to you. That again is another week or two. So, as you can see, it's even for an expedited process, you're still looking at probably several months. So the more lead time you can give yourself and your tenants, and the more notice, the better.
Okay. Thank you.
Absolutely. Thank you. Let's see. All right.
Is there
Anyone
anyone
else?
else?
Going once, going twice. I'm looking through everyone's names here. I don't see any hands. Um, And if that's the case, then I guess we'll wrap up the presentation for today. Thank you all for joining. Thank the city for bringing me in to do this. As I said, we are going to be doing this as a series. September 16th is the next one. The subject matter will be moving in and out and security deposits. That will all be fresh in everyone's heads who is turning over their property on or around September 1st. We'll talk about abandoned property, disposition of security deposits, to security deposit statements. We'll go back to photographs and some other issues, and maybe because that's such a fact intensive thing, we'll leave a little bit more time for questions at the end. So again, thank you all for joining. Thanks to the city for sponsoring this. There also is a link here on this last slide. That URL there will take you to the city's rental resources site. They've got lots of forms, including forms for moving in and out checklists, other sorts of things that are good resources for you all to have as landlords and property managers. Thank you all for joining us today, for your time. We appreciate you joining. Hope to have you again in September. Thank you.